Is a false 498 a case destroying your family's peace? Or are you worried that your elderly parents and distant relatives are being dragged into a matrimonial dispute they have nothing to do with? The law has changed, and so has the Supreme Court's stand. From IPC 498A to the new Section 85 of the BNS, the rules for protection are now stronger than ever. Today, I'm revealing 7 landmark Supreme Court judgments from 2022 to 2026 that prove vague allegations are not enough to put you behind bars. We are talking about the latest 2026 rulings that every husband and in-law must know. Watch this video till the end to learn how to quash false FIR and protect your loved ones using these powerful legal precedents. Let's dive in. I'm Advocate Mukund Mahajan, and you're watching Legal Information, Law Insights. If you find our content valuable, please consider becoming a channel member via the GPay QR code on your screen for 59 rupees or 119 rupees. Your support helps us continue providing high-quality legal education. Now, let's dive into the details. Today, we will discuss 7 landmark Supreme Court judgments from 2022 to 2026 regarding the misuse of Section 498A IPC, now Section 85 of the Bharatiya Nyaya Sanhita, BNS, 2023. These judgments are critical because they clarify 1. When cruelty is actually established. 2. When false cases can be quashed. 3. How the law protects innocent relatives from harassment. Judgment 1. Dr. Sushil Kumar Purbey v. State of Bihar. Judgment date 9th March 2026. Bench Justice Vikram Nath and Justice Prasanna B. Wale. Citation 2026 INSC 212. Status reportable. Significance establishes the principle of parity. It holds that if a high court quashes a case against one relative, like a sister-in-law, due to vague allegations, it cannot refuse the same relief to other relatives, like parents, if the allegations against them are identical. Protects in-laws. The decision reinforces that strained relationships or disputes between a couple do not automatically constitute criminal cruelty, IPC 498A, by in-laws. Judgment 2. Rajesh Chaddha v. State of Uttar Pradesh. Judgment date 13th May 2025. Bench Justice B.V. Nagarathna and Justice Satish Chandra Sharma. Citation 2025 INSC 671. Status reportable. Significance highlights the retaliatory nature of FIR. The court ruled that complaints filed shortly after a husband initiates divorce, which lack specific dates or medical evidence of injury, are often abuse of process and should be quashed. Misuse of law. The judgment acknowledges a trend of using Section 498A to maliciously implicate families and stresses that missing particulars in a complaint weaken the prosecution's case. Context of complaints. The court noted the necessity of examining the timing of FIRs, particularly if they follow divorce petitions. 3. Belide Swagath Kumar v. State of Telangana. Judgment date 19th December 2025. Bench Justice Vikram Nath and Justice Rajesh Bindal. Citation 2025 INSC 1471. Status non-reportable. Significance defines matrimonial wear and tear. It clarifies that a husband's behavior, such as maintaining strict expense accounts, Excel sheets, or supporting his parents financially, does not meet the legal threshold of cruelty required for criminal prosecution. Preventing misuse of Section 498A, the ruling highlights that the 498A provision is often misused as a tool to settle personal vendettas or as a counterblast to matrimonial proceedings, like divorce or restitution of conjugal rights, initiated by the husband. Vague allegations invalid. The court affirmed that general, sweeping accusations of mental or physical harassment, without specific instances, dates, or details, are insufficient to continue a criminal case. Protection of in-laws. The judgment reinforces that family members, particularly those residing in different cities, should not be dragged into criminal prosecution based on generalized accusations. 4. Maram Nirmala v. State of Telangana. Judgment date 16th December 2025. Bench Justice B.V. Nagarathna and Justice N. Kotiswar Singh. Citation 2025 INSC 1496. Status non-reportable. Significance addresses omnibus allegations. The court emphasized that when multiple in-laws are named in a charge sheet without assigning a specific, overt act to each individual, the proceedings against those family members must be quashed. The criminal liability under Section 498A is strictly personal and demands precise evidence rather than vague assumptions. By dismissing omnibus allegations against family members, the Supreme Court protects the law's credibility and ensures serious legal provisions are not misused through careless drafting. 5. Rajesh Sharma vs. State of UP. Judgment date 27th July 2017. Bench Justice Adarsh Kumar Goyal and Justice U. Lalit. Citation 2018 10 SCC 472. Status reportable. Significance the foundation judgment. Although from 2017, its principles govern all modern 2025 to 2026 rulings. It issued specific directions to prevent the mechanical arrest of the husband and his relatives immediately after an FIR is registered. Arrest of the collateral accused such as father-in-law, mother-in-law, brother-in-law or sister-in-law etc. should only be made after prior approval of DCP on file. 6. Dara Lakshmi Narayana vs. State of Telangana. Date of judgment 10th December 2024. Neutral citation 2024 INSC 953, also reported in the Supreme Court cases as 2025 3 SCC 735. Bench Justice B.V. Nagarathna and Justice N. Kotiswar Singh. Significance quashing of an FIR under Section 498A IPC, addressing the misuse of dowry laws and vague, omnibus allegations against in-laws in matrimonial disputes. Rejection of omnibus allegations. The court reiterated that vague and general accusations, known as omnibus allegations, against the husband's family members are insufficient to sustain a criminal trial. For an FIR under Section 498A, cruelty, to stand, there must be specific, distinct roles and incidents attributed to each relative. Protection of distant relatives. In this specific case, the appellants included the husband's brother, sister, and brother-in-law. The court noted that they were living separately from the couple. The allegations against them lacked proximate or direct connection to any specific act of cruelty. Allowing the trial to continue would be an abuse of the process of law. 7. Kahkashan Kausar at Sonam vs. State of Bihar. Judgment date 8th February 2022. Bench Justice S.A. Nazir and Justice Krishna Murari. Citation 2022 6 SCC 599. Status reportable. Significance the modern landmark. This is the primary authority cited in almost every quashing petition today. It warned against the growing tendency of wives to implicate all of the husband's relatives to settle scores, even when those relatives have no active role in the dispute. The court observed a growing tendency to implicate all family members of a husband in matrimonial disputes without specific evidence. The judgment clarified that relatives cannot be prosecuted based on vague or general allegations. Specific instances of cruelty or harassment must be attributed to each individual accused to sustain a criminal charge. Key takeaways. From these judgments, the following legal principles emerge. 1. Vague allegations are not enough to sustain a trial. 2. Routine marital friction is not criminal cruelty. 3. Parity matters. If one relative is cleared, others with same allegations should be too. 4. Retaliatory FIR, filed after divorce, are viewed with heavy suspicion by the courts. Conclusion. These judgments clarify that Section 85 of the BNS, formerly 498A IPC, exists to protect genuine victims, but the Supreme Court will intervene whenever the law is misused to harass innocent families. Thank you for watching this video. If you found this information useful, please like, subscribe, and share your views in the comments. Don't forget to press the bell icon for more legal information. I will meet you in the next video soon. Jai Hind. Jai Bharat.